Vigorous defense. How can you describe vigorous defense as incompetent defense?
Certainly, the respondent is not emphasizing
You
this.
must make up your mind.
The respondent has always made up his mind. That is, even if this council did discharge its duty so-called rigorously, as defined in the compromise, the mere assignment of legal counsel and mere denial of her right to choose her own counsel without interest of justice and denying her right to self-represent herself, which is entirely possible, is that already renders the whole trial
Are you
fair.
saying that if we were to decide against the country you represent because of your incompetence, that would be a ground for them to claim compensation against you?
Perhaps that could be a ground, Your Excellency. Of course, this is another imaginary matter, and this, as Your Excellency has
Would it
suggested...
then render this entire hearing invalid? Because you failed to put your case forward properly? Would it then render this entire hearing invalid according to international principles of international customary law?
No, Your
Which are in
Excellency.
serious dispute now?
Two responses. First of all,
You don't have to answer that question.
perhaps it will also be important for me to answer that.
Yeah, okay. Briefly. Yeah.
Two responses. First of all, is that my defense is rigorous enough and it is competent. And secondly, that the governments of Fotherland and respondent at both second and first
And time is
respondent
extended by 5 minutes.
were not forced assigned counsel by the ICJ or by the other party, and therefore it is entirely irrelevant.
But you're talking about assignment. Coming now to serious business. You're talking about assigned counsel. In the United States, in the United Kingdom, and in other jurisdictions, even in South Africa, there is a system by which counsel is made available by the state, either through legal aid or the public defender's office. Right?
Certainly.
Now, if such a thing had happened in that jurisdiction, that would have been quite all right, because someone would have been assigned to argue the case. But why then is it wrong for what they did in this case?
Legal aid, and or the inability for one to pay for its own counsel is a main difference here. In those cases, and in fact in many jurisdictions around the world, if one cannot afford its own counsel, of course he has to accept an assigned counsel from that state. But here, there is no evidence to suggest that Ms. Tbilisi could not afford her own counsel, and in fact there was also no evidence to suggest that she was not competent to represent herself. Unless this case was somehow akin to the Milosevic case, where, for example, Milosevic disrupted the whole trial himself, or when his counsel disrupted the whole trial, there is in fact no interest of justice as to why there should be an assigned counsel.
But in this case, the accused was tried by a court comprised entirely of lady judges. So if there was sensitivity, it was actually in her favor.
Understandably, yes, but the respondent in fact does not complain about the constitution of the panel.
Which means the conviction must be right.
That is another matter, as long as there was
Because
assigned
a
counsel.
properly constituted panel, whoever may be counsel assigned, would have appreciated the facts. Assuming, going back to that bad example I gave you just now, assuming you were making a mess of this case. Which you are not.
I'm not considering.
You're not. But you're assuming you were making a mess of the case. Does that absolve us from dealing with the case on its merits?
Your Excellency.
Answer that question.
Yes. The answer is no.
In which case, it doesn't matter who counsel was who was assigned. The ultimate test, the acid test, is whether the court was a competent court. And if you accept that the court was a competent court and you have no complaints about it, then the fact that counsel was assigned becomes irrelevant. Do you agree?
No, Your Excellency.
If a court is a competent court in the sense not of jurisdiction, but it's a fair court, a fair trial has been given, then the fact that counsel was assigned must be irrelevant, because the right decision has been arrived at.
Your Excellency, there's a difference between fair trial of the outcome and whether the panel was fair. That is the constitution of the panel. And
But
respondent...
that must be miscarriage of justice. By assigning counsel, there must be a consequence. There must be something, an act or omission must produce a negative result. If the same result would have been produced even if competent counsel had been assigned, or she had picked her own counsel, how could that be an injury?
Precisely, Your Excellency, but this is based on assumption that had she not been assigned counsel,
But you
had she...
accept that the court, you have no complaint about the court, which means the result must be by a court which knew what it was doing. So
No.
it didn't matter whether competent counsel appeared or didn't appear.
No, Your Excellency. The respondent will lastly emphasize one point before moving on to the next
No,
issue.
you answer this question first.
That is,
You're not going anywhere without answering this question.
that is, assignment of counsel, as repeatedly mentioned by the respondent, per se, can render the whole trial unfair. And Your Excellency's question,
Why?
in Lopez in Uruguay, in US in Hiroshima, in Ward in Texas, and in numerous, for example, in Anderson in Switzerland, numerous cases around the world suggest that if no circumstances justify assignment of counsel, this per se, will render the whole trial unfair.
Extend time by 2 minutes.
Thank you very much. So, Your Excellency, unless you have any further questions, I will then move on to the diplomatic
Yes.
embassy incident. Very briefly, the respondent...
How can you assign 3 policemen and ask them to hold back 300 people? Is that appropriate? You call that appropriate steps?
Two responses to that, Your Excellency. First of all, the 5 guards were assigned before...
Sorry, not 3, 5.
5 guards were assigned before the crowd arrived. That is, they were regular guards. Second response is that in Tehran hostages case, as pronounced by Your Excellencies, in an incident on the 14th of February 1979, Your Excellency has accepted that a 5,000 crowd versus 10 to 15 guards was sufficient. Here, 300 crowd, 5 guards, obviously the ratio is much above as what Your Excellencies agreed.
Iranians are not as aggressive as perhaps the Burgundians, the foreign people of this.
You mentioned that the 5 guards were there before the crowds arrived.
Yes.
But that doesn't seem to be stated in the compromise.
That should be, according to the interpretation of the company.
What are you looking for?
I was just asked by Your Excellency about whether the 5 guards were already there. May I read from the compromise?
Yes, I'm looking at it.
There were 5 fraudulent police guards assigned to protect the embassy. There was nothing to mention that these guards were assigned after the incident, and it would be very easily implied that, of course, an embassy, there would originally be guards.
I think what is in your favor is that there were 5 reasonably, or they were already there.
Yes.
The ordinary sense of that
Yes. Your Excellency,
But why did you all bring in some extra force when the crowd swelled?
precisely within half an hour, reinforcement police were assigned.
You said
And-
that is sufficient steps.
Yes, and as pronounced
And
by
as for the shooting incident,
the shooting incident, as Your Excellency has a question of my learned
you
friends,
adopt our argument.
that is
Because you have no valid argument against it.
certainly not, Your Excellency. We, in fact, in agreement with Your Excellency that the mere shooting was accidental. And in fact, contrary to what the applicant suggested,
Let me ask you the question. I think your opponents bring the point. I know that I'm using domestic law terms to an interpretation of the Vienna Convention. In your opinion, the protection, is it a strict liability offense regardless of fault or regardless of